For those of you who don't know us, my name's Tom Grant. I'm a senior associate in the National Insurance Disputes team here at Mills and Reeve. I'm joined today by Andrew Spence, who is an associate and colleague of mine in the same team.
Good morning,
Before,
everyone.
Today, we're going to take a look at the contrasting approach of the Ombudsman and the courts when dealing with insurance coverage disputes. We start with the Ombudsman, looking at its role, statutory framework, and jurisdiction. Then we consider the court's approach with its narrower focus on statute and case law. We think that looking at the topic in this way provides quite a useful snapshot of the differences between the two approaches and throws up some interesting questions and hopefully some practical tips for insurers when considering coverage disputes.
Thank you, Tom. So looking first at the Ombudsman, as most of you are probably aware, the Financial Ombudsman Service, or FOS, has jurisdiction to consider complaints when dealing with a wide range of financial matters in the UK. And these include banking services, mortgages, pensions and investments, consumer credit, financial advice, and most importantly from our perspective and for the purposes of today's session, insurance, including coverage disputes between insurers and policyholders. So you can see on the screen that there are 5 qualifying criteria which must be met for FOS to consider an insurance dispute. The insurer must either be authorised FCA or be a participant in FOS's voluntary jurisdiction. The dispute must relate to regulated insurance activity. The complaint must be brought by either a consumer, a micro enterprise, or a small business. The insurance activity must be from a UK establishment. And lastly, the complaint must be brought within 6 years of the event or within 3 years of when the complainant became aware of the problem. So, FOS was established by the Financial Services and Markets Act 2000, commonly known as FSMA, to provide dissatisfied customers with a quick, cost-free avenue of potential redress. FOS must determine complaints by reference to what is fair and reasonable in all circumstances of the case. Now, great, you might say, but what does fair and reasonable mean in practice? Well, FSMA sets out the purpose and function of FOS together with a snappily titled document, Dispute Resolution Complaints Rules, which we'll refer to as DISP rules. One of the key elements of the DISP rules is that FOS must take into account relevant laws, regulations, rules, and guidance codes of practice. However, unlike the courts, the Ombudsman is not strictly bound by them and may actually depart from them when considering a complaint. So in simple terms, FOS has a statutory discretion to reach a conclusion on complaints when it considers it fair and reasonable. And in doing so, it's not strictly bound to apply the law. If a decision deviates from established legal precedent, FOS can make an award which is binding on insurers, provided that it's reasonable to do so and the reasons for its decision are clearly explained. So clearly, and reasons are the key terms here. Legal disputes, whatever your status, are ultimately governed by the law, and our analysis is largely based on how we think the courts will apply it, whereas FOS has a discretion to deviate from that approach and only take the law into account when making its decision as to what is fair and reasonable. It's therefore ultimately up to the Ombudsman to decide what weight to lend to the applicable law. That's particularly significant when annual average FOS case numbers continue to rise exponentially and increase by around 40% between 2023 and 2024.
Thanks, Andrew. So the approach taken by the Ombudsman is really well illustrated in the case that we've referenced on the slide. Just briefly, the case involved a married couple, Mr. and Mrs. M. They took out a joint life insurance policy with terminal illness benefits. In August 2013, following the breakdown of their marriage due to changes in Mr. M's personality and behaviour, the joint policy was cancelled by Mr. M. Insurers also obtained Mrs. M's written consent to the cancellation. Around that time, Mr. M was also referred for psychiatric analysis and a CT scan to establish the cause of the changes in his behaviour. Now, whilst awaiting the outcome of those investigations, Mr. M took out a new single life policy with the same insurer. However, and crucially, he failed to disclose his ongoing referral for psychiatric assessment and a CT scan at that time. Shortly after the policy commenced, he was diagnosed with an aggressive terminal form of dementia, and a claim was notified to insurers for terminal illness benefit. Insurers declined cover on the basis of misrepresentation. A complaint was subsequently made to FOS on the insured's behalf in relation to the handling of both the joint and single life policies. Now, a summary of the FOS decisions is on screen. FOS rejected the complaint in relation to the joint life policy, but the complaint was actually upheld in relation to the single life policy. Quickly on the joint life policy, whilst Mr. M had been experiencing symptoms at the time the policy was cancelled, insurers had ultimately followed the correct process by obtaining clear written consent for the cancellation from his wife. However, in relation to the single life policy, the Ombudsman considered that whilst insurers should have been advised of the referral for psychiatric assessment and a CT scan, they found the misrepresentation was innocent because the nature of Mr. M's illness was such that he could not be expected to make the same disclosures a reasonable person would have made. So off the back of that, an application for judicial review was lodged with the court by insurers seeking an order to quash the FOS decision in relation to the single life policy. Insurers said that FOS had failed to take into account relevant insurance law and practice, which in this case was the Consumer Insurance Disclosure and Representations Act 2012, or CIDRA, which at the material time entitled insurers to avoid a policy where they could show they would not have written the risk at all if the misrepresentation had not been made. It was accepted there was no concept of innocent misrepresentation under CIDRA, and FOS conceded that the final decision was actually therefore flawed for inadequate reasoning. As Andrew explained earlier, whilst the Ombudsman wasn't required to strictly apply the relevant law, in this case CIDRA, it was incumbent on them to carefully explain any reason to do any failure to do so. No clear reasons had been given for the departure from CIDRA in FOS's decision, and this resulted in the decision being quashed. And that's consistent with the authority we've mentioned on the slide. Now, the legal effect of quashing the decision was ultimately that the complaint remained in place to be redetermined at a later date if necessary. Quickly turning back to the judicial review application itself, it was also argued by insurers that the Ombudsman's decision to uphold the complaint in relation to the single life policy had shown what's known as Wednesbury unreasonableness. In other words, it was so unreasonable that no reasonable person would have made it. Because FOS had acknowledged that the decision was flawed for inadequate reasoning and should be quashed, it wasn't necessary for the court to form a conclusive view on Wednesbury reasonableness, but it did comment on the issue from both perspectives. The court recognised that insurers require proposal forms to be completed accurately so that the risk may be properly valued and the premium assessed. It also agreed that some weight must be given to the argument that fairness and reasonableness is not just about the interests of the insured, but must also accommodate the commercial interest of the insurer. However, the court did consider that the inaccuracy on the proposal form for the single life policy had not been caused by any morally culpable error on the insured's part. Rather, it was innocent due to the nature of Mr. M's illness. The court accepted that despite the position in law, which supported the insurer's approach, an ombudsman who, quote, properly directing herself as to her powers, could reach a different view. However, as we've said, clear reasons had to be given for any decision to uphold a complaint and to depart from the law, and these had not been supplied. So the facts of that case really highlight that tension we've talked about between a strict interpretation of the law on the one hand and the Ombudsman's discretion to reach a decision which it considers fair and reasonable in all the circumstances of the case. It was noted by the judge that if the insured had brought legal proceedings against insurers in the county court, the claim would have failed on a strict interpretation of the law. It was correct that CIDRA did not recognise the concept of innocent misrepresentation, and insurers were therefore legally entitled to avoid the contract. But the novel circumstances of the case meant that the Ombudsman could reach a different view, provided it clearly set out its reasons for disapplying the law. Here, as we've said, it failed to do so, leaving the complaint open to be pursued again. Now, The judge's comments made in postscript are interesting as they capture this conflict between the two approaches quite neatly. The full excerpt is shown on the slide, and the key comment from our perspective is where the judge said, I do have personal concerns about a jurisdiction such as this, which occupies an uncertain space outside the common law and statute. The relationship between what is fair and reasonable and what the law lays down is not altogether clear. Who or what defines the contours and content of fairness and reasonableness? And I think that really sums up the issue, doesn't it? Who does decide what is fair and reasonable? The suggestion in the jurisprudence is that it exists close to the law, but is that really enough? I think at the very least, it certainly leads to real uncertainty for insurers and their complaints handling teams, even in instances where they're conducting themselves entirely within the remit of the law and in accordance with industry practice, as they did in the case we've just discussed.
So the situation clearly throws up some very interesting questions. Is it fair and reasonable to fix an insurer with liability where no such liability would exist at common law? From a lawyer's perspective, and I'm sure most of you will agree, the answer feels like it should be no. However, advocates of FOS would say that where FOS's opinion as to what is fair and reasonable is perverse or irrational, that opinion is liable to be set aside on judicial review grounds. Their argument is that insurers are protected from unfair outcomes in that way. Now, the judge noted in Heather Moore and Edgecombe that arbitrariness on the part of the Ombudsman, including an unreasoned and unjustified failure to treat like cases alike, would be ground for judicial review. However, one might question whether that's difficult to achieve in practice with an ever-increasing number of complaints being made to FOS. Another question is whether judicial review is a viable route for firms and individuals to challenge decisions. A University of Sheffield study identified that over a 17-year period between 2002 and 2019, just 26 judicial review cases involving FOS actually progressed to a hearing. Now, when we consider that FOS received 142,000 complaints in the second half of last year alone, that demonstrates just how uncommon judicial review is in this context. And finally, it's important to note here that this is not all in the insured's favour. Decisions do go both ways. Latest stats published by FOS from Q1 2024 and 2025 confirm that complaints relating to commercial property insurance were upheld at a rate of 39%. Buildings insurance complaints were upheld at a rate of 40%. And so the inverse of that is that 60% of these decisions are going in favour of insurers. Whilst this raises interesting questions and issues from a theoretical and a philosophical standpoint, we also think that there are practical points for insurers to consider when dealing with coverage disputes. Remember that outcomes are fact-specific on a case-by-case basis. So in the case Tom discussed, the Ombudsman suggested that the question is whether an Ombudsman properly directing herself as to her powers could rationally conclude that it would be fair and reasonable to uphold the complaint. So insurers could consider both approaches when undertaking coverage analysis, i.e. do the black letter analysis first, and then take a step back and consider whether the outcome is fair and whether the insurer has behaved reasonably. Now, clearly, that's a very difficult and uncertain exercise for insurers. Our recommendation would be to be guided by the law in the first instance, whilst remaining aware of FOS's discretion, particularly in circumstances where a policyholder has challenged the decision and indicated an intention to refer the complaint to FOS. We should also remember that if a complaint is referred to the Ombudsman, FOS can request a copy of the insurer's file, save, of course, for any privileged documents. And ultimately, they'll want to see that the matter has been handled professionally. We've covered a lot there in a short space of time, but here are our key takeaways before we wrap up. Even if a policyholder has erred in the eyes of the law, say by breaching a conditions precedent, the Ombudsman may still intervene and apply principles of fairness and reasonableness to achieve a more balanced outcome. And FOS is perfectly entitled to do so, provided that it explains its reasons, particularly where the decision deviates from the law. Fairness cuts both ways. Just as an insured might argue that enforcing the letter of the law would be unfair and unreasonable, it's open to insurers to make the same argument. And not unsurprisingly, the Ombudsman's decision is binding on both parties once it has been accepted. Whichever side they ultimately favour, FOS decisions are very difficult to challenge by way of judicial review. And the limited number of judicial review cases that reach trial reinforce that view. The court cannot substitute its own view for that of the Ombudsman. Those challenging a decision must show that the decision is unlawful by reason of an error of law, as in the case Tom discussed, or by way of irrationality. And even where a challenge is successful and a decision is quashed, it's entirely possible it'll be redetermined and FOS will reach the same decision again, but with more developed reasoning. And all that suggests that it may often be sensible for insurers to negotiate and resolve complaints at a very early stage where possible, because costs of judicial review are likely to be very significant.
Yeah, thanks, Andrew. So hopefully today's discussion has helped shine a light on that uncertain distinction between the law on the one hand and what the Ombudsman considers fair and reasonable on the other. The judicial comments we've seen obviously encourage real consistency and rigour in the Ombudsman's decision making in terms of applying the law and when and why it's appropriate to depart from it, bearing in mind that fairness and reasonableness applies equally to the interest of the insurer as well as the policyholder. But as we've seen and as Andrew's discussed, that consistency is very difficult to achieve in practice. Against the backdrop of an increasing number of complaints to FOS and some calls for reform of its role, we think it's really important to be aware of these issues when dealing with coverage disputes, which may ultimately fall within FOS's remit. As things stand, and for the reasons we've discussed today, where insurers are facing a complaint which instinctively feels like one that occupies that grey area between the law and what is fair and reasonable, we think it might be sensible to negotiate and resolve that complaint, even where doing so, it may mean going against our usual collective tendency to apply the law very strictly. Now, I'm very conscious of the time, but Harriet, do we have any questions and do we have time for them?
We've certainly got time for one, if not two, and this is in some part an observation as well. But the question is that you mentioned earlier on about what fair and reasonable is, and that where, for example, the Ombudsman's opinion was perverse or irrational, the likely outcome would be the setting aside of the opinion on judicial review, and thus insurers would be protected. But you have to ask yourself, hang on a moment, should insurers go to such lengths through the litigation process to secure a sensible outcome? The whole use of the phrase fair and reasonable is so subjective that to use it as a guideline to reach a sensible decision is almost perverse in itself. One asks oneself, as I'm sure the questioner did, surely the court processes should do better than that and look to make the rule of thumb more objective in a way that the quoted man on the Clapham omnibus might. Do you have a view on that, either of you?
I mean, it's certainly a valid observation, very valid. I think the numbers Andrew talked about in terms of just how many judicial review applications end up being heard, on these sorts of cases is testament to the fact that it's not necessarily an accessible or remotely accessible remedy for insurers or policyholders for that matter. In terms of the requirement for a decision to be perverse or irrational to be set aside on judicial review grounds, I mean, because there are so few cases on it, we don't really know how that would be approached by the courts. I think all we can say with any confidence is it would be a very high bar. It's difficult to know what would meet the criteria. I think as an insurer, you would have to be very confident that the decision was almost, as the questioner said, objectively flawed. If that was an argument and or irrational, if that was an argument you were hoping to run, it would certainly be a high bar, and given the costs involved, a brave insurer that tried to run that argument.
Yes, perhaps we need a think tank, and this will help it along.
Right. Yeah.
We'll see. Well, we don't have any more time to carry on, so I'll pass the baton back to you, Tom, please, to finish
Thanks,
up.
Harriet. Thank you. Thanks, everyone, for joining us today.